All right, we are just about streaming.
All right. Hopefully, we are currently online. This is March the 9th at approximately 1:07 p.m. And this is a meeting of the Criminal Law Subcommittee of the Judiciary Committee of the House, Maryland General Assembly. Today, we are going to be discussing three bills: House Bill 336, sponsored by Delegate Addison; House Bill 1061, sponsored by Delegate Williams; and House Bill 566, sponsored by Delegate Martinez. I'm taking a roll call. We have with us this morning Delegate John Carden, Delegate Conaway, uh, Delegate McComas, Delegate Woods, Delegate Moreno, and Delegate Arakan. Missing is Delegate Embry and Delegate Congolo, and hopefully they will join us before the end of the work session today. So today we're going to begin with a bill that we discussed last week, which is House Bill 336 from Delegate Addison. We're going to hear from, once again, and with a reprint. Has everyone received the reprint? If anyone has not received the reprint, please let us know.
Sir Chair, I don't see the reprint. Was it emailed?
I believe a reprint was emailed. Theo, if you could, and Delegate Addison, I
Oh, wait
believe.
a minute. We're doing 336. Please accept my apologies. Yes, I did receive that reprint. My apologies. I was looking at the wrong bill.
Very good. So we have online with us, we wanted to limit the discussion. So we have online with us the State Attorney's Office, Delegate Addison, and Ms. Laurie Ruth. If Delegate Addison, if you would like to, or you would like to have the State's Attorney's Office take us through the amendments that you've proposed, we would start there. Mr. Giordano?
Oh, okay. I was waiting for the delegate. Yes, sir. Thank you, Mr. Chairman. As you can see by the outlined amendments to the bill, as discussed previously, so this bill now would allow for a district court commissioner to issue a summons across the board. What it also does is limit the warrants being served by a district court commissioner across the board as well, but in those who are eligible for relief under Title IV, Subtitle 5, which is the domestic violence cases, they would have 72 hours, meaning they recommend all cases will be sent to our office. We will review them, and within 72 hours, we will make the recommendation of charges moving forward and the issuance of the summons or the warrant being issued. Or I'm sorry, the warrant being issued, not the summons. They issue the summons, they wouldn't come to us.
Okay. So I want to make clear. So all outside of DV, the court commissioners would be given the authority, as they have today, to issue a summons for any matter. If the matter is DV, then those would be, particularly if they are prepared to issue an arrest warrant, specifically an arrest warrant, the state's attorney's office would receive those and have 72 hours to say yes or no. What happens if they don't make a determination in 72 hours?
If they don't make a determination, then they're good. The state's attorney's office is going to be in trouble. So the problem and the reason why, and I know we had talked about this previously, we didn't get into, well, if it's after 72 hours, then it automatically becomes a warrant, because then you get into a sticky ground of, okay, well, is it 72 hours after the individual went to the court commissioner? Is it 72 hours after the court commissioner sent it to the state's attorney? Is it 72 hours after the state's attorney received it? And so in that case, who's going to make the determination of issuing the warrant after the 72 hours? So it would then lie on the state's attorney's office to make that issuance within that 72 hours.
So what relief does the complainant have? Should you said it's like the state's attorney gets in trouble. I don't know what that means.
Well, I mean, the onus typically falls on us, right? Like at the end of the day, we would be the ones who have to, within that period of time, make the determination. And the court commissioners in the courts, I'm sure, will follow back up with us to say, all right, it's been X amount of time. We need to understand relief for this particular complaint. And it will be on our office to do such. But we will be the ones making those recommendations.
Okay. All right. So the amendment has been offered. Any comments from any of the members of the committee? Any comments or questions?
Yeah, I have a question. This is Delegate Archon.
Hey, Delegate.
Go right ahead, Delegate.
Thank you so much, Mr. Chair. So what's the next pathway to relief then? As the chair said, let's say I was a complainant. I did not hear back in more than 72 hours. Can I go and refile them? What is my next step in that process? And is that outlined in the bill? I don't see an outline for that, but there needs to be a next step to remedy.
So Delegate, you're right, it's not outlined in it. We will welcome the outline. The problem is I guess the same way as you would now. If there's a warrant issued and the warrant just sits and nothing's being done, or even a summons, like what's the next step? The only next remedy would be for them to go back and file again. In this particular case, I know this doesn't comfort anybody on the committee, but I sincerely doubt that with all eyes being and the onus being on the state's attorney, that they're going to allow it to lay. Now, it is up to a court commissioner can contact the state's attorney's office and say, hey, you told us we've got 72 hours. It's been 83. We haven't gotten a decision back. Are you going to move forward with this? Can we issue a warrant or a summons? And then it would be on that state's attorney's office to make that determination to that district court commissioner at that point. The only caveat that we would see in immediately issuing a warrant if we hadn't replied in 72 hours is just that. It may not have gotten to 72 hours from our time clock, and then within 73, they issue a warrant. And then if we're not going to move forward with the case, it's very hard to recall that and bring that warrant back, right? After it's been in it, at least from our perspective. And so, I understand what you're saying, and we welcome a conversation on moving that forward. But the issue would be mute if the court commissioner contacted our office and or they refile. We don't want to have a victim refile, right? That's the last thing we want, is to put the onus on a victim to have to come back and do it all over again. So we are more than willing to listen to the recommendations of this committee, Ms. Ruth, and let's see how we can get to a pathway forward that satisfies everybody.
Okay. All right. Any other questions of Mr. Giordano?
Mr. Chair, this is
Yeah.
Claire.
Yes, Claire.
I just want to clarify which set of amendments we are talking about. If it is 983229/1, because if so, I just wanted to point out a bit of a discrepancy that I think when Mr. Giordano explained this, if he's talking about these amendments.
That's the last one I have, and I'm assuming
Okay.
that's the last one that people have.
I thought I heard Mr. Giordano say that these amendments allow a commissioner to issue a summons.
Yes, ma'am.
But actually the way they're written, they say that the district court shall immediately forward an application for statement of charges filed by an individual who's not a police officer to the state's attorney. Any application for statement of charges, they just give it to the state's attorney. The state's attorney investigates it, recommends whether a statement of charges should be filed. And they also, and if it's a domestic violence type case, they have, the state's attorney has 72 hours to make their determination. But in any event, the attorney has to recommend, has to say, yes, a statement of charges should be filed. And they make a recommendation as to whether the court should issue a summons or arrest warrant. And the commissioner may only issue a summons if the state's attorney says they can. And the commissioner can only issue an arrest warrant if the state's attorney says they can. So I just wanted to clarify that the commissioner has to, for a state application for a statement of charges filed by somebody who's not a police officer, the commissioner has to wait to hear back from the state's attorney as to whether they can issue a warrant or a summons under these amendments.
So it sounds like that was not the intent and that was not the agreement. Is that correct, Mr. Giordano? Because I think in our discussions, the court commissioners would continue to be able to issue a summons. Is that correct?
Correct. That is correct. And I see exactly what the delegate is saying with
that's counsel. That's counsel.
that's counsel. Okay, I'm sorry.
That's the person
yeah.
that's supposed to keep us straight, which she's done exactly what she has done.
Absolutely. I think if we strike 4-2, the district court commissioner may issue a summons under subsection only if the state's attorney recommends. If we just take that out and just keep the district court commissioner may issue a summons, period, and take out the under subsection only on the state's attorney recommends it. No, that's for district courts. That's the judge.
Okay.
That's not a court commissioner. They're right. So
Okay.
we need to change that. You're right. Thank you, counsel. That needs
Okay,
to
you're
be-
welcome. I can fix the amendment if that's what you all want to do.
Yes, ma'am.
That was the understood stand. That was what I understood both the sponsor of the bill and the attorney, the state's attorney intent. Okay. All right. Anything else that you would like to say, Mr. Giordano, or anything else from the sponsor, Delegate Addison? Okay.
Hi, Delegate Phillips, can you please let Brian in so that he can listen in on the call as well?
He can always listen.
Well, for information.
All right.
Well, thank
I'm
you.
trying to think that we agreed that we'd get one party. Theo, I'm going to allow it. Theo, if you could let Ryan in.
And that delegate, Brian Levy deals with these cases on a regular basis for OPD. He can definitely talk a lot better and more frequent than I can on the legal side of things. So,
Okay. All right. We're trying to work this out because I know.
yes, sir.
Thank you.
All right. All right. So now, are there anything else that you wanted to suggest? Because I want to move over because I want to hear from Ms. Ruth.
Chair Phillips,
Any
thank
other
you, but
questions? Any other?
Delegate McComas has had her hand up forever.
Oh, I'm sorry. I missed Delegate McComas' hand. I'm trying to look at too many things at the same time. Delegate McComas, please. I apologize. So Delegate McComas.
That's okay. My first case ended up on the front page of the Sun, and I think I've said that before, but the thing you have to understand is this would have been the third time he was a hostage taker, and he held the person hostage. The problem was they went to the commissioner didn't, put him in. Basically, my concern, bottom line, is sometimes you need a warrant, and you need it today. You need it immediately. You can't wait for a state's attorney to bless it and up to 72 hours. And that was a situation where it went down from a psych eval, a commissioner, and then it went to the person holding the girlfriend and the baby hostage. And within a 24-hour within probably less than 24 hours. And the SWAT team was out there and they were going to pick him off. Okay, it didn't happen. It was fine, but there was all kinds of lawsuits. There was a malpractice lawsuit. There was a criminal lawsuit. There was a Senate case. It was a three-ring circus. What I'm trying to say is that if somebody is juiced up, okay, and they're upset and they have mental problems, the bottom line is it's going to go down faster than you can ever hope. And 72 hours is crazy. Somebody has to be able to realize it's an imminent situation. And I think the commissioners should be able to do that if they feel that it is imminent. And that was an imminent situation. And I was the defense attorney, so I didn't get involved in all this stuff. I was just, the person to clean it up. So I think that's something I'm very, very concerned about. We don't have time. We need somebody to be able to move on it quickly. And so we have to have a guarantee. And I think the domestic violence folks would agree. We have to have some way that if this is a very, very urgent situation, that it can be taken care of immediately and not have to wait. I mean, I understand neighbor disputes and everything, but on domestic violence, it's a different animal, and it's very concerning. So that's where I'm coming in. And I thank you for listening to me. Thank you.
No problem, Delegate McComas. And I want to, and I'll play devil's advocate on both sides. It's one of the reasons I asked Mr. Giordano the question I asked him. At some point, you've got to weigh harm on multiple fronts. The reason that the delegate brought this bill is because too frequently the commissioners are making decisions based on false statements. They are limited to the four corners of the document, and they make those decisions, and arrest warrants are issued. The other challenge that we have, and we heard it very clearly, is even in those extenuating circumstances, warrants are not being issued within a 24 to 48 hour time period. And so do we have an opportunity? Is there a window to have the state's attorney review it, considering the fact that it's probably on average far more than 72 hours by the time a warrant is issued? And on top of that, you've got this issue of the ability for kind of alternate routes to get an arrest warrant, one being the police. So the commissioner isn't the only source of issuing an arrest warrant. I'm going to stop there because once again, we're hearing from folks, and before this is over, this body is going to be asked to take a vote. Any more hands up? I still see your hand up, Delegate McComas. I don't see any other hands up. All right, we're going to move.
I'm sorry. I hate to be this way. Delegate Conway has his hand up.
I keep moving, and I don't see. There, I see Delegate Conway's hand. Okay, Delegate Conway, go right ahead.
Yeah, my hand was up a long time while you were talking. But anyway,
I got to change the way I'm viewing. Go ahead.
Okay, thank you. So for Delegate McComas, what do you mean the guy was all juiced up? Was he exceedingly angry, or what are you saying?
What I'm saying, he's had a history of taking marijuana and PCP, and it's been over 30 years since I've reviewed that case. But what I'm saying is that he was under a lot of emotional stress. He was very upset. He borrowed the gun from his brother, told him he was going hunting. Okay, yeah, I guess, I don't know. And he wanted to see his child, and that he broke through a plate glass window and held them hostage. And when I said juiced up, he probably was on PCP and marijuana because that was the drug of choice. So he also had significant issues. And the bottom line is it was a very serious problem. And they went to the commissioner. They had him evaluated with a psychiatrist that only talked to them over the phone. He never came into the hospital. That's where the malpractice came in. So what I'm trying to say is things happen quick. And,
right, but he did talk to a medical professional.
On the well,
as prescribed. No,
he
I
was
can't.
never seen. He was never seen by the medical professional. The guy never came in. And so that was there was a malpractice suit, and the doctor settled it. The psychiatrist.
Okay, thank you, you, Delegate.
Yeah.
Okay, Ms. Ruth, and I know that there was a amendment that I saw coming from, I don't think I got it from you. I think I got it from Miss, from Lisa.
Yeah. Thank you, Mr. Chair. Lisa did tell me she gave you a paper copy of our proposed amendments after we left Delegate Addison's office last Wednesday. That's what we had been discussing there, not with Mr. Giordano, but with Ms. Winkler and another gentleman whose name I forget. I'm sorry. I appreciate your counsel pointing out that as drafted, these amendments do not do what Mr. Giordano said. And I appreciate Mr. Giordano for understanding that. And I rely on counsel to make it right, because part of my concern on Friday when we got these was that we had gone backwards and taken away the ability for a person eligible for relief to get a summons. So thank you for that work. I think Ms. Jordan and I are still concerned for the very reasons that Delegate McComas very eloquently just stated. And our proposal, we think, strikes that balance, Mr. Chair, that you are trying to make by saying that a commissioner could issue a warrant if the alleged crime or alleged assault, alleged domestic violence had happened within the prior 48 hours, because that's what law enforcement is allowed to do now. They are allowed to arrest without a warrant if the crime was committed in the prior 48 hours. And so, you know, we have worked really hard to come towards the way the state's attorneys would like to see this and Delegate Addison would like to see this. I have also made really clear that if the bill was only for people, citizens who are not persons eligible for relief, there would be no opposition to this bill. So a baby step would be to limit it to that and see what happens for a year or two if neighbor disputes and bar fights and everything else are not allowed to get a summons or a warrant, and see if that lightens the load of these false statements of charges. But barring that, we would really ask for consideration that a warrant could be issued by a commissioner with, if the crime, the alleged crime that was committed within the prior 48 hours before going to the commissioner. I understand if they're waiting 2 weeks and then filing a statement of charges, you know, they can wait another 72 hours for a warrant. But if they come in visibly injured, harmed, petrified, and probable cause is there, we believe for safety's sake, they should get a warrant. So that's the first thing. There are a couple of other things that keep coming back, which is, you know, I think this conversation about what happens if the state's attorneys do nothing within 72 hours is really important. And if you went with our amendments, a summons where the commissioner's like, I'd love to give you a warrant, you know, but I'm not allowed to, but I'm going to send the summons to the state's attorney's office with a recommendation for a warrant, and the state's attorneys could elevate that. Same with a warrant that a commissioner issues because the crime was within the last 48 hours, the state's attorney could review that. But I think that some state's attorney's offices and our meeting with Delegate Addison, the state's attorney, you know, Ms. Winkler said herself, like, we don't know that all the state's attorney's offices in the state have the capacity to do this within 72 hours. And so there has to be some accountability on that part. So I think, you know, if within 72 hours nothing happens, then the warrant would go into effect, or the summons would at least stay in effect. I haven't really thought it through because I wasn't sure, again, what arena we were working in. But we also thought about having some reporting, collecting some data for 2 years to see how this was working with the state's attorneys, because the way it's drafted, even if we come to an agreement, there's no accountability of the state's attorney's offices and what they are doing and whether they're adhering to the 72 hours. The other thing we talked about in Delegate Addison's office was, you know, if Mr. Bates' office has concerns, without a statute, they could institute a policy that if a warrant or summons comes across their desk that was the result of a citizen complaint, then we have to address it within 12 hours. Mr. Bates seemed to assert in testimony last year and this year that his office can do these things. They have the capacity. They have a state's attorney on, on duty 24/7. And so, there are ways short of cutting off the safety ability of persons eligible for relief who really, really need it, short of cutting off their ability to get a warrant. And thank you again for allowing the summons to at least be issued. So those were a couple of things that we had concerns about. And, we are not, the last one that nobody has mentioned, and I fully admit nobody has mentioned because we've been so involved in how to do this, is how is the citizen going to know what the state's attorney decided? And should that be in the statute? Because 72 hours goes by, she's sitting at her parents' house hiding from this person. And I don't know how she's going to know or he's going to know what the state's attorney actually decided. And so they don't know whether they can go back to their house. They don't know, is there victim notification when the person is, when the summons has been sent to them, or when they receive it, or is there a victim notification when a warrant has been served on the abuser? How does the victim, the citizen who filed that statement of charges, know? So, I'm both frustrated and pleased by the conversations that we've been having over the past few weeks. I wish they had happened before the bill was dropped, because then we would have had more time and maybe been able to flesh some of these things out. And the more we sit and think about it, the more we think about unintended consequences or things that have gotten left out of the conversation, like victim notification. So I will stop there. All of you all have a copy of our proposed amendments, which includes that if the crime was within the prior 48 hours, the commissioner can issue a warrant. And it's not that they must or that they shall issue a warrant. They're still going to do their assessment that they do now between whether it should be a summons or a warrant. And, I thought we agreed on that very first phone call, Mr. Chair, that we were going to not allow non-persons eligible for relief under the statute to get a summons or a warrant and get rid of that. I just have one more thing to say, which is I did a little bit of research, and because people in the hallways and when you talk about this bill say, do other states allow this? And the answer is yes. So I believe I just sent it to you in an email and
You
to,
did.
yeah. So
I don't know
other
if you shared it
states,
with the other members of the committee. If not, you should. And I know there were probably about 7 or 8 states that you mentioned, and 3
yeah,
that seem to be applicable.
Pennsylvania, North Carolina, Arizona, Idaho, Wisconsin, New Jersey, Ohio, Alabama, and Georgia. And admittedly,
But all of
about
those
half,
are different. They don't necessarily have
exactly.
a system.
About half of them do require some sort of either state's attorney, or they call them in most states district attorney, or judicial review of some sort. Pennsylvania has state's attorney review, but if the state's attorneys decline the statement of charges, it can go to a judge for a review of the state's attorney's decision. So there are all these different menu items out there that other states are doing if we cared to spend more time on this. So I'll stop now, but thank you very, very much for letting me have my say.
Okay, no, I appreciate it, and I'm gradually losing my delegates. Yeah, I am. Wow. Okay, so we may not be voting on this yet. Again, I do want to get other thoughts in. Delegate Conway, did you still have your hand up? Did you need? Okay, he's taking his hand down. And Mr. Giordano, did you want to make another comment?
Yeah, so I want to clarify. Thank you, Ms. Ruth, that I may have misspoken with the council. So we did agree that those not eligible for relief, there's no summons or warrant issued, that all those cases go to the state's attorney's office for review.
Mm-hmm.
In terms of the summonses, only in cases of domestic violence or within the relief. But the warrants would be looked at with the state's attorney's office and issued within 72 hours. So, Madam Counsel, I don't know if and I don't think the bill still doesn't reflect that what we're saying right now.
So let me be clear. So
Yes.
the commissioner could not issue a summons for a criminal matter. It would have to be referred to the state's attorney.
Correct. For other than DV. Correct.
Other than DV. And for DV, they would be able to issue a summons for DV, but they could not issue a warrant. Those would have to be referred to the state's attorney's office.
Correct. And our argument would be, and I hear what Ms. Ruth is saying, but that 48 hours that you're putting somebody behind bars then puts the onus on them while they're sitting behind bars and may be innocent of that and waiting for the justice process to work, instead of us giving us that 48 to 72 hours to review the case to make sure. Because to be quite honest, most of the cases that we see, the person's running down there who are saying, because they know what to say, oh, so-and-so hit me, so-and-so had a gun, and there's no physical evidence whatsoever that they've been assaulted, that any of this ever happened. And so that's kind of where we're coming up on, of those real one-offs that you're talking about. And I'm not saying it's one-off because it could be quite a few, as well as the thousands of innocent men and women across the state who are being victimized by this system. So
and that's what, and so to your point, Mr. Jim, that's what this bill is trying to weigh.
Correct.
The bill is trying to weigh the potential for, what Delegate McComas talked about. That case, fortunately, that case did not end up in death. But look, when I started my career, I'll share the story. When I started my career, I was doing a lot of family-related matters. And I can remember a very heated divorce for people that had been married 30 plus years, but it gotten to a terrible place where my client called me and I was representing the wife. She called me in the middle of the night and she said, I believe my husband is driving, up and down. He had an ex parte, wasn't supposed to be anywhere, driving up and down in front of my home, and I'm afraid. And literally, I picked up the phone because I had the relationship. I called the precinct. The precinct went out and found the guy about a block away sitting in his car with a gun. So I understand the urgency, right? I really do understand the urgency. At the same time, I've also had the unfortunate opportunity to represent those individuals who've been falsely accused, who end up in jail and they spend a weekend in jail or maybe longer than that and lose jobs and lose livelihoods and lose relationships because people see them as having done something wrong when at the end of the day, that prosecution, that couldn't be supported. And I know you see a lot of that in Baltimore City, unfortunately. But this is not just a city problem. This is a statewide problem. And that's why we're taking this very seriously and trying to figure out how do we balance, right? How do we balance this? All right, Mr. Levy.
Thank you.
No, hold on, Mr. Levy. I'm sorry. I see the Delegate Addison.
Oh, hi. I'm so sorry. So I just wanted to chime in and just say that I thought that all statement of charges will go to the state's attorney's office, as Claire said in her, when she was, the council was in her amendments. Is that not correct?
So as it stands today, all charges would be referred to I believe the amendment that you all forwarded, all charges would be referred to the state's attorney, but only the DV charges would have to have a response in 72 hours. So the other charges might sit for a longer period of time, and we haven't put any parameters around that, which that's a whole different issue. And that's the amendment that we have before us, Delegate. Mr. Levy.
Thank you, Brian Levy, the Office of the Public Defender. I do want to emphasize that I think it is crucial that all charges do get forwarded to the state's attorney's office for review. And the reason for this, when we talk about this problem, it's not simply a city problem. The problem is the four corners of the document problem. The commissioner cannot corroborate any of the allegations made. It is the duty of the prosecutorial body, the state's attorney, to investigate and figure out, is there corroborating evidence? Is this case viable? Is it frivolous? Is it false? Before issuing charges. Charges themselves, the issuance of charges is going to cause people to have to hire attorneys, to go to court, and oftentimes lose their jobs, face collateral consequences. So although being falsely arrested is a huge problem, it is also a huge problem to be charged with something that was never reviewed by an investigatory body. I did want to respond to Ms. Ruth's proposed amendment that would allow warrants to be issued if reported to the commissioner within 48 hours. I don't think that solves the issue because unlike the police, again, the commissioner cannot investigate. The police, when they are coming in within 48 hours and can make an arrest, they can see, are there injuries? Are there witnesses? Do these statements add up? Is this somebody that has a history of falsely reporting? Does this person have false charges against them? Right? One of the ways we see this system most abused in my practice as the head of a district court division at the public defender's office is by perpetrators of domestic violence going to the commissioner to have their partners arrested falsely and charged falsely using the commissioner as a shield against their own criminal liability. And those are the situations where I see regularly someone would go down to the commissioner and say, she punched me in the face, she attacked me, charges are now issued against that person. And let's say it's a cross-complaint situation, those who have represented these cases, now the state's attorney's office can't talk to that actual victim. And so I hear that there's a need to protect victims of domestic violence. And I take Delegate McComas's example well, that there are situations where this is urgent. We need to do something now. We have the police. The police can go out and make arrests now. They can investigate the issues now. In a situation that calls for it, they can do a warrantless arrest now. We certainly still have civil protective orders. So this bill, as currently proposed, as Delegate Addison's amendment, does strike that right compromise, saying we are going to prioritize domestic violence cases for review, but we're going to do so without the harm of causing people to be arrested and charged with crimes without any investigation whatsoever into the allegations. Thank you.
Thank you. Okay, members, this is your opportunity to ask questions. We're going to ultimately, because I don't even know if we have a quorum. We're going to have to come back and vote on this. But this is your last opportunity to ask questions of both Ms. Ruth, Ms. Delegate Addison, Mr. Giordano, or Mr. Levy. If there are no questions, that's going to be our work session.
Delegate McComas had a question.
Delegate McComas, I'm sorry. I keep missing. I got to do better. I'm sorry, Delegate McComas.
No, that's okay. I guess it's because I'm on the end here. Thank you, Delegate Woods. I appreciate it. Real quick question. Do we have any data today as to whether it be in Baltimore City or any of the other jurisdictions where there has been these false reports and then they were later found to be false, and we've got some analysis so we kind of know what's happening on the ground just somewhere, because it's really hard for me because I'm balanced. If I was a commissioner a long time ago, and you when you see a victim come in and they are harmed, okay, now that's, but also the fear, in the situation I talked about, there wasn't imminent fear at that. I mean, there was fear, but there wasn't imminent, abuse, physical abuse that was seen. But I mean, everybody was very, very concerned because this person had a history. So that's my concern. And, I really kind of, I wish we had some data here that I could get a handle on, to help, because I would always err, if I were a commissioner, I would err on the victim as opposed to the person that was, what do I want to say, had problems with the charge, because if you don't want to be responsible for somebody's death. So that's what I'm thinking, because no one knows what's in the human heart. And that's my concern, is that we could miss some of these things, because a lot of these domestic violence, they can happen when you don't even know it's going to happen, and where people have had protective orders. And then we had this one lady years ago that came to judiciary, and her significant other threw acid on her, and her whole arm was totally abused. And he did that at the Harbor Place, because she worked in a store. So that I guess we have to be concerned about the unknown and future victims, and it's scary business.
And I hear you, Delegate McComas. I think we have to be very careful, because when you say victims, both sides could be victims in this, and that's the challenge. So Delegate Woods. No, wait a minute. I'm sorry, Delegate Addison. Did you want to say something else, Delegate Addison?
I did. Thank you so much. I wanted to let Delegate McComas know that I sent over the data that I received from Ms. Ruth and also from Judge Morrissey. So she might want to look at that, because that has data on it as well.
Yeah, there are two pieces of data that were sent by Delegate Addison to all of the members of the subcommittee. Yeah, Delegate Woods.
So as I listen to this, and because of my line of work, it's really a struggle, because the reality is you can have people, and I believe it was you, Chair Phillips, who talked about, I'm not sure who it was, who talked about the perpetrator coming in and saying that the victim actually abused him.
Mr. Levy.
And I've seen that before. And somebody talked about fear and convincing. I have seen some of the most fearful, convincing, not just men, women also, both fearful and convincing perpetrators pretending to be victims. And to be honest with you, you'd be surprised how difficult sometimes it is to determine who is the actual perpetrator and who is the actual victim. And so I just want to emphasize how important it is, when we're thinking about how we're doing these arrests, and as it was stated, the difficulty that some people have trying to prove their innocence, that has those unintended consequences that impact child care, impact them being able to keep their children, impact their employment, impact a lot of things. I just wanted to say that for the record.
Very good. All right, we're going to bring this to a close. I'm going to ask, we'll talk to Hunter about scheduling a members only discussion on House Bill 336 this week. We'll try to get that in, and hopefully we can do that in a matter of about 15 to 30 minutes. If there are any other suggested amendments, Ms. Ruth, we have yours. Mr. Giordano, we have yours. If you want to make changes to what you've submitted, you need to let us know. I'm going to request that we meet again this week, probably on Wednesday. All right, so that ends the work session for House Bill 336. We're going to go to House Bill 1061 with Delegate Williams. And I was told that Delegate Williams may not make this, and that I believe her chief of staff and a member of Prince George's County. Oh, yeah, Prince George's County State's Attorney's Office. I see Delegate Williams' picture, but I'm assuming that's not her.
Hi, Mr. Chair. My name is Michael Marino. I'm her chief of staff.
Mr. Marino, how are you, sir?
I'm great. Thank you for having me.
Yep, and I see ASA Steve Wildman. All right. Now, as I understand it, there are no amendments to this bill. All right, this bill is clean. Okay. You want to give us a real quick update? I do recall this hearing. State's attorney came in, Ms. Delegate Williams came in, and this is about being able to use firearm charges from other jurisdictions in consideration for charging in Maryland. So give us 60 seconds and tell us what you'd like us to do.
Sure. I will, if it's all right, defer to Mr. Whitman from the state's attorney's office.
Thank you, Mr. Moreno. Thank you, delegates. In short, we are asking for a fix to a loophole that exists in 4203 of the criminal article. 4203 of the criminal article prohibits an individual from carrying a firearm if they lack a permit in the state of Maryland. 4203 also contains within it already enhanced penalties for subsequent offenders. What it doesn't do is allow us to contemplate subsequent offenders whose prior record occurred somewhere else. So in effect, it forces us to be harder on people that are, native or local to Maryland and local to the county, rather than folks that committed their first crime somewhere else and then came here to commit their second. We're not in any way opposed to people exercising their Second Amendment rights. We are just asking for the legislatures, help in closing this loophole so that we can treat all of our defendants fairly.
Very good. Ms. Erica.
Thank you, Mr. Chair. I just wanted to confirm, hopefully I'm not freezing. I just wanted to confirm, was there any opposition to this bill? I can't recall.
I don't believe there was any opposition to the bill. If so, it might have come in afterwards.
Okay, yeah. I feel like the 2A people were fine with it. I have a similar bill for fourth-degree sex offense, this exact same problem, where we're penalizing our locals. But if you are a serial fourth-degree sex offender from out of state, you can't even have it introduced during sentencing. So, okay. All right. Thank you, guys.
All right.
Chair, I'll just chime in here. There was a little opposition. There was a private citizen, and then the ACLU opposed it just for, according to their testimony, another way to stack defendants' criminal charges. So I just wanted to clarify there was two oppositions.
Yeah, the ACLU letter, did it come in late?
Let me check.
I think
yes, it did.
It came in late. Okay. All right. All right. Any real opposition? Mr. Conaway, Delegate Conaway.
Thank you, Chair. So what the bill is going to allow a charge from another state to be considered in this state. Is that correct?
Correct.
But some states don't allow the same laws that other states allow. Is that right?
When you say the same laws, they may not have, so a concealed carry in Virginia may be different than a concealed carry, impermissible concealed carry might be slightly different than here. Would that be correct, Mr. Wildman?
Yes, sir. And in fact, I did a little research on that before coming in today. Most of our bordering jurisdictions, I'll be honest, I didn't look at all 50, but all of our bordering jurisdictions, except for Pennsylvania, have fairly similar language to what we're asking you guys to do. If a subsequent offender for a firearm charge in particular happens to be in Virginia, in Delaware, and West Virginia even, we can count that, or they can count ours, but we can't count theirs. And in short, that's a bit of a challenge.
They can count ours.
Correct. So in Virginia, and I was aware of that. So in Virginia's code, if you have a prior handgun violation in Maryland, they consider that in their prosecution in Virginia.
Even if it's something that Virginia allows?
Yes. If it was a prior conviction,
right,
in Maryland, yes, they consider that. They consider your past conviction.
Okay, thank you.
Yeah, Delegate McComas.
Thank you, Mr. Chair. I guess my concern is somewhat like Delegate Conway's. Each state is unique and each state is different. And obviously, if the surrounding states are quite comparable to ours, that's not as big a problem as if someone lived in, let's say, California, and they had more stringent gun laws than, let's say, Maryland. Then that would be counted, even though Maryland doesn't have that strict a law. So I think it's only fair that people don't know this is not something that's going to be that obvious to folks. And I guess my concern is more penalization of folks that would not be aware of what's going on. They understand the laws of Maryland. They try to abide by the laws of Maryland. But I'm surprised that nobody came in and opposed it, because I think it's not as transparent as we would hope it to be. So that's kind of where I am.
Yeah, Mr. Wildman, do you want to answer that before I move to Delegate Ericon?
Yeah, there's a short answer to that, I think. There's a long answer too, but we'll stick with the short one. The language we've asked you to add is a similar offense in another jurisdiction. I think that's the exact words in the proposal. And with that, where we see that in other parts of the law, we see that in, for example, the DUI statute or the prohibited person statute. That puts the onus on us, the prosecutors, to verify that that prior conviction would count if it had occurred here in Maryland.
Okay. Does that answer that question, Delegate McComas? I think you're on mute. You're talking to mute, Delegate McComas.
Okay, all right. It may sort of work all right, but I think that my concern is that this is a good way to just take away people's gun rights when they may need them. That's all. I'm surprised nobody kind of came in and complained about it. I don't know if we really need it, quite honestly. Maryland's gun phobic, so.
All right. Delegate Ericon.
Thank you, Mr. Chair. Yeah, I understand where Delegate McComas is coming from. There definitely is some gun phobia, but most of the states around us actually have more lax wear and carry laws than we do. So, and I do think it's concerning if somebody is potentially, look, if they're carrying a firearm in West Virginia and they get in trouble for carrying it illegally, they're a prohibited person. They're not supposed to carry it in the first place. And I think that's true for many of the other states. And certainly that's the direction most of the country is going in, frankly, is the constitutional carry. If they have violated gun laws somehow in a constitutional carry state, I just don't know how we wouldn't introduce that as evidence. They're a criminal. They're a prohibited person. They're not supposed to be carrying a firearm because they've used a firearm likely in the commission of a crime, or they're a domestic abuser of some kind. So I think that's probably why the 2A people didn't come out in opposition to this, because those are the very people that they're the reason why we carry guns, so that we can protect ourselves from those exact people. So I'm not as wary about that. I do hear the California argument. I think a lot of those laws are going to be found to be unconstitutional in the long term anyway. So I do believe that the country broadly is headed towards a more constitutional carry framework. And I think we don't want to let essentially prohibited persons come from out of state, carry firearms illegally, commit crimes in our state, and not get the potential increased penalties, which brings me to my question. Is this, again, more sentencing related? Is this so that we can introduce it at sentencing, or is this at charging? I mean, I know for my bill, it's just at sentencing the evidence is introduced because we don't want to prejudice the outcome. But can you explain that, Mr. Weidman?
Yes, and I'm so sorry to correct you, Delegate. It's Widman. I'm working on the
Widman, please correct me. I've got a weird name.
So you can sympathize.
Yeah.
Okay, so it is primarily a sentencing issue, not a charging one, for the same reasons that you talk about. We're not attempting to prejudice. Obviously, that would be inappropriate. Subsequent offender is an issue for notice to the defense, which obviously needs to be brought up long before sentencing, because we want to include that in our plea negotiation. But we find ourselves in a bit of a weird bind when it comes to should we introduce it as evidence in a trial. The short answer to that is unlikely would it be brought up during trial. I can see a kind of weird and nuanced circumstance where it might occur if the person's also charged under a different statute, and then chose not to stipulate that they were prohibited.
Okay.
Then it could come up. But the judiciary has made it very clear that if defense seeks to stipulate to their prohibited status, then we, the state, are obliged to accept that stipulation so as to avoid prejudice.
Okay.
For that exact reason.
Okay. So, and without this bill at sentencing, could you even introduce the evidence that the person was prohibited? I mean,
yes,
right now?
I could introduce the fact of their prior, and it would affect their Maryland guidelines for the sentencing commissions. The Maryland sentencing guidelines would be affected. However, in a de minimis way. So right now, if I had a individual get charged with a first time wear carry, let me say that a little differently. If I had two defendants and one had a DC pistol without a license and one had a Maryland wear carry, so essentially the same crime, and now we're on the second iteration of that here in Maryland, or for the DC person under the current law, their first time. So the DC prior, the first timer is looking at a guidelines of probation to 2 years and a maximum of 5 years. The person with the Maryland prior is looking at a maximum of 10 years and a guidelines of 4 years to 9. And that's just, quite frankly, it's unfair to our residents and our citizens. Even if they are committing crimes, we should be treating them fairly with anyone else from out of state.
Right. Yeah. Okay. I think that helps me think through it a little bit better. But I do hear the concerns of Delegate McComas, and I don't think they're non-existent. Some of the state gun laws are horrible, but also these are likely people committing gun-related crimes. That's why they're prohibited elsewhere.
Very good. Any other questions for Mr. Whitman?
Delegate Cardin has his hand raised.
Delegate Cardin.
Thank you, Mr. Chairman. Just real quick, I just based on that conversation, does this apply to both people who are Marylanders who have out-of-state convictions and non-Marylanders who have out-of-state convictions? Would it apply to both?
Absolutely, sir.
Okay, very good. Thank you.
All right. All right. This one seems like we've gotten some clarity. Is there a position? And I'll start with Delegate Ericon. How are you feeling about this one? Because you're my gun person. I got to know.
Yeah, I have a little bit of discomfort, but since, Mr. Pinnock, 2A Maryland and Maryland Shall Issue did not issue a negative review of it, I feel fine moving forward with the language as it's currently drafted. I think they do a bang-up job of digging through all the constitutionality behind things, and if they don't see an issue, I don't see an issue.
All right. Well, on this one, so we can move it out, the chair will take a motion. I know Delegate Ericon is not going to make that motion. Delegate Cardin.
I'll make a motion favorable.
All right.
I'll second it. It's fine.
Second. Okay.
Yeah,
Very good. All right. We'll do. Any further discussion? No further discussion. I'll do Delegate Cardin.
Sorry. Yes. Yeah.
Okay. Delegate McComas.
No.
Delegate Moreno.
Yes.
Delegate Conway.
No.
Delegate Woods. Delegate Woods. Did I lose Delegate Woods? All right.
I'm sure you have enough to move it, unfortunately.
I got 5 out of 9, so we've got a majority.
Oh, we have 5?
Yeah.
I know, but I just mean, does that equal, even if I vote yes, does that even equal enough for us to move it?
Yeah, I think it does. Yep.
Yeah,
Delegate
if the chair votes.
All right. Well, Delegate Ericon.
Yeah, I vote yes.
Okay. And to keep it straight, the chair votes aye. All right. We've got 1, 2, 3, 4 in the affirmative and 2 in the negative. Yeah. So
Delegate McComas has a question.
Yes, Delegate McComas.
Oh, no, I don't. I'm sorry.
Okay.
Sorry about that, folks.
All right. Yeah, we got 4 in the affirmative, 2 in the negative. We'll move forward with House Bill 1061. All right. We're going to take a few minutes. We're not going to vote on House Bill 566. And also plan on, I got to talk to the chair and to Hunter about a members only, it'll be just the members of the subcommittee to hash out House Bill 336, hopefully on Wednesday. But House Bill 566, it's a
Delegate Phillips?
Yes.
You have another committee going on now.
At 1 o'clock. Okay. All right. Well,
2 o'clock.
At 2 o'clock. Well, I'm gonna allow, who's coming up next? What committee is that? Public safety?
I don't know.
Juvenile, I think, right?
Juvenile, oh, that's why Delegate Woods left. All right, very good. So we'll end so you all can get to your next committee. House Bill 566 is going to be on our docket and House Bill 336. All right?
Thank you all so much.
Thank you so much. Appreciate it.
Thank you all.